welcome to Toronto Echo 2014. We are here live from the Grand Hotel. Toronto Echo is really a television series focused on news in the entertainment business and financing. The series is broadcast by Rapid TV News. We are happy to have with us today on a panel that's dealing with intellectual property. What you need as a filmmaker to know about protecting what you're doing, how to protect it, and some of the ins and the outs relating to the intellectual property aspects of your film project. We have here today Scott Miller, who's a partner in MDM, and we thank you for coming. We've got to my right Jeff Schiller, who is a partner with me in the law firm of Deutsch, Levy and Engel. Thank you, gentlemen, for coming.
Thanks, Gordon.
We want to start out, and I could really throw it out to really both of you. Here's an example. Screenwriter writes a screenplay. Screenwriter says to you, I've protected it already because I've registered it with the WGA. Who wants to start answering that? Does that protect?
Sure. So from a copyright perspective, you obtain registration and that gives you the right of protection, and the protection is a substantial taking. Has someone substantially taken your work? If the rewrite is so drifted from the original document, then is there a substantial taking if someone else takes the rewrite but not the original document? And that's a measuring spectrum that I would consult with a lawyer to determine how variant the original work is to the second work.
Yeah, so Scott, the person who comes to you and says that he's registered with the WGA, her Writers Guild, that doesn't give them the protection that a copyright does.
No. So copyright, in depending on the jurisdiction, I'll speak to Canada, Jeff could speak to the US. In Canada, the moment you put pen to paper, you own the copyright. In Canada, registration gives you additional rights above and beyond just having the copyright. So without a registration, you could sue someone in Canada and your ability to obtain damages would be nil. You can get an injunction to prevent the ongoing use, but registration enables you, and it's relatively inexpensive, but registration enables you to A, sue for monetary damages, and B, there's a presumption of ownership and authorship, which doesn't come with unregistered copyright.
Jeff?
In the U.S., it's pretty much the same, except for one thing. In the U.S., you have to have registered in order to bring any kind of lawsuit. You can't get an injunction, as well as you can't get damages or statutory damages or anything of those sorts. So it's really important. You get a right in a copyright when you put it down, but you don't have an enforceable right. You can't enforce the right until you copyright your work. And the registration is cheap, it's simple, and it's something you ought to do as a matter of course.
All right, so with the same example, screenwriter is taking your sage advice and has, in the United States, it's $35, and you file with
Canada, the registration fee is $65.
Okay.
It's very
so
inexpensive.
it's really not okay. So they have done that. They followed your advice. They have put a copyright on it. In the development phase, which is the phase that happens before pre-production, the development phase, what else should they be concerned with, Jeff? What, from an intellectual property standpoint?
Well, if you consider the possibility that at some point you're going to be merchandising or selling things about the film, then you want to trademark certain things as well as copyright them. Trademarking is, as opposed to the idea itself, the expression of the idea, which is copyright. Trademark is something that you do to protect the public, yourself, in terms of the public's right to understand where the work is coming from. So you can trademark words, you can trademark designs, you can trademark logos, you can trademark shapes, you can trademark things that allow you to identify you as the source of origin. If you want to trademark, for example, the phrase, "May the force be with you," and then sell coffee cups, sell t-shirts, sell whatever you want. That doesn't get you from copyright, because copyright is an entire work, and that's not a substantial similarity. But if you're going to sell something, services, goods, something related to your film, you need to trademark as well.
Are there similarities in Canada?
So, just to add to what Jeff had said, let's go back and talk about what substantial taking means from a copyright perspective. If you register an entire work and someone takes out a very small portion of it, they may not be taking a substantial taking. So if you have a work which becomes very popular, you may wish, because it's so inexpensive on the copyright side, to register a small component of the text, say, of an entire script, as an example. The other side of it is when you're actually having the work prepared, who is actually the owner of the copyright is a question which should be examined. So, for example, if the writer is an independent contractor, that writer owns their work unless there's a contract that says otherwise. If the person's an employee of a production company or whatever, some kind of company that's preparing the film, the company will own the first work. So it's imperative to understand that if you're hiring someone or you're the writer itself, you need to ensure that you're protecting the rights which you want from a copyright perspective, meaning put things in writing as to ownership of your work.
Jeff, when we go forward and there is a company that's formed, and the company, and they call you and they say, we've had someone design a logo that we own, and this is a logo for the production company as they move forward. What advice might you give to that person?
Well, you want to do several things. The logo, again, you're probably going to want to trademark, because if you're going to use a logo, logos are used with the intent to sell something in the future. Otherwise, there's no purpose to having the logo. If you want to sell, you need to trademark. You need to copyright the material itself, the original material, but you need to trademark the logo. You need to make sure, as Scott pointed out, that you do in fact own the logo and there isn't an independent contractor who's created it and owns it. So you need to set forth a contract if it's an independent contractor. If he's your employee, not a problem, you own the logo. If it's an independent contractor, you need to make sure that there's a contract that gives you the logo rights so that you have them in case the film hits very big and someone claims that they have the right to the logo instead of you.
And so there's no common law copyright similarity to trademarks, right?
If I could jump on that, it depends on the jurisdiction you're in. A point I would make about the trademark side of this is that it's important to understand, before you even create the title of your film, it might be advisable to reach out to a trademark lawyer to ensure that it's not been done by someone else, so you don't have issues of common law passing off. So trademarks can or cannot be registered. If they're not registered, you have what's called common law rights, which the moment that a trademark starts to be used, you start accumulating these rights. Now, if someone else used before you and you come out with this film and it turns out that there's this pre-existing title out there, you might run into some significant problems. So straight from the gate, it might be advisable to either do a search yourself online, a quick search, where you can reach out to the USPTO or the CIPO in Canada and just do a Google search, or just try to find it yourself, or if you're prepared to spend some dollars, reach out to a trademark lawyer who can do a quick search for you.
Yeah, the difference is that you can do all that you say to protect your title, but when you put the title to the movie, the MPAA that puts the ratings on your movie will send out the title to every production company in the universe.
Right.
And any similarities or any even similarity to a word in your title, there will be an objection filed. And your lawyer has to go to the examiner and try and differentiate your title from every other, like Pleasantville, title of the movie, Smallville, Uville, Ittsville. Anything similarity with Ville in it there'll be the objections.
And that's exactly what happens in a trademark context when you go to the USPTO or the CIPO. If there's similarities, you're going to wind up with potential objections. You're going to wind up with office actions from the examiner who's going to want to know whether there are similarities. So you absolutely need to do a search in advance to be prepared for that type of situation.
Yeah, it is the mind problem that I have with all this. You could be as artfully and legally protected, and you could have someone at the MPAA that just says to you, "We're not going to rate your movie."
Right.
And then all the work that you've done and all the expense that you've done, they got to spend again because this organization, the MPAA in the United States, decides that they're not going to rate your movie because you have not satisfied the examiner there of the differences in your title. So in the development phase, as I understand it from the two of you, we're concerned with copyright and we're concerned with certain trademark issues.
Much more copyright. Trademark only comes into play if your movie is going to create commercial issues beyond the sale of the movie.
All right.
So, but we didn't finish answering one of your questions, which was the distinction between common law and registered rights with respect to copyright versus trademark.
Right.
And in Canada, again, the moment pen is put to paper, both in the U.S. and Canada, you have an entitlement. The registration, all right, common law is before registration, and registration is a different right. In fact, in copyright, there is no common law right per se, all right? Copyright is a creature of statute, both in Canada and in the US, all right? And the creature of statute, the right that is given from the statute before registration in Canada is somewhat different than the US. In Canada, you can still sue someone for an injunction if the person knew or ought to have known of your copyright. As I understand Jeff's earlier comments, in the US, you must have a registration in order to seek an injunction and or damages.
Registration is an element of the copyright claim.
Right.
Now you can register after you do your work. You can register before the infringement. There's something called timely registration, which is if you register within 3 months of the actual production or publication, or if you register prior to an infringement, you have what's called timely publication. That gives you certain presumptions. It gives you certain statutory damages.
Right.
The other thing I want to add on with Scott is there's one other difference too that feeds into this, which is copyright has something called the Berne Convention. And where the Berne Convention is concerned, if you've written a screenplay in Canada, that is presumed to have been developed everywhere. At least everywhere that is a Berne Convention signee, which are the large.
So what is the Berne Convention?
The Berne Convention basically says that if you are the signees who are the large industrial nations, there is a right, it is recognized that what you've created in Canada, in the US, it's as if it's been created in any of these countries. You still have to register it, but it's as if you've created it. By contrast, in a trademark sense, if I trademark "May the Force be with you" in the United States and sell coffee mugs, but I never sell anything overseas, I don't sell on the internet, I don't make any other sales, I don't have a right in France, in China, unless it has become so associated with my product that it would deceive the consuming public over there.
So there's no similarity of a Berne Convention as it relates to trademarks?
That's not completely true. There are conventions where if you file in one jurisdiction, for example, if you file a trademark in Canada and you get priority, so
Right.
you have up to 6 months to file in the US, and the filing date in the US will be deemed to be the same date as the date in Canada for up to that first 6 months. So you can prevent someone's intervening rights in the other jurisdiction.
Right, but
Okay, but just Canada.
Sorry?
I mean, there aren't other countries that have signed on, to the Berne.
Well, Berne is a different type of convention. There are trademark conventions
Right.
where the
Madrid.
priorities are given.
Madrid
So,
as well.
okay. So, and to answer the question earlier, we were finishing with respect to trademark and common law and what that means versus registration. A common law trademark, again, the second you start using a logo, the second you start using a fanciful phrase that you want to trademark, you have rights the moment you start using, and that's called common law rights. But when you go to sue somebody, and I believe this is the same in the US, you have to sue for what's called passing off at common law. And in order to sue at passing off, you have to show reputation, which in some cases could be difficult because the reputation has to be in the geographical area in which you're suing. Whereas with a registration, when you get a trademark registration, you're deemed to have used that registration throughout the country, so the reputation question becomes much easier, and you do not sue for passing off, you sue for what's known as trademark infringement, and the tests are much easier met for trademark infringement as opposed to passing off.
that's absolutely the same in the US with only one caveat, and that is, in the US, you may wind up suing for both. And the reason is because in certain jurisdictions, Illinois, where Corky and I come from, is one, there are consumer fraud acts which allow you to get certain types of relief in terms of attorney's fees, punitive damages, in ways that are not as easily available. There's a greater burden of proof under the trademark laws. So you probably sue for both, but the initial trademark claim is a much easier claim if you do exactly what Scott said.
All right, so now we have a movie. The movie's made.
Good, that's good.
It's funded. What are our concerns as it relates to intellectual property and protection of the finished movie?
All right, so you have, in today's world, with downloading and streaming, you have a whole host of new issues vis-a-vis privacy and whether or not you can go after an individual or do you go after the corporation that's the provider of this information. From a copyright perspective, downloading is a much easier question to answer because when something's downloaded, a copy is made on the computer, the smartphone, whatever the case might be. When a copy is made, it's frankly a no-brainer. So when there's downloading, you can sue the individual for copyright infringement. With respect to streaming, it's a whole different game. The tests in the US and Canada are somewhat different because when you stream, you don't actually make a copy as an individual. What you're doing is you're watching an instantaneous. So the service provider could be sued for streaming, but in Canada to date, the individual who streams, it's much more difficult to chase them because the communication is a performance and not a reproduction when the individual consumer is watching. So hopefully the law will evolve a little in Canada to make it easier to go after the individual, but currently there's much more strain to seek relief against an individual streamer.
How is it different?
It's not that different. The US just had a Supreme Court decision a couple of months ago in a case called Aereo. And I don't want to get into all the details because we don't have the time to do that. But in 30 seconds or less, Aereo tried to claim that it was selling its stream by means of tiny miniature antennas that were dedicated to individual users. And it claimed that not only wasn't it doing a public performance because the individuals were the ones getting it, but that it wasn't performing at all because it was the individuals who were activating the stream. And the Supreme Court in a 6-3 decision ruled that that was not the case, that that was a performance, it was a public use, and as a result, it is much easier in the US to go after the streamer and the person who is watching the stream. It's going to be an interesting progression as we move forward because that decision was hotly disputed, and there's already been a New York Second Circuit decision distinguishing the Aereo decision. So the technology moves faster than the law does, and you're in a situation where even people who are practitioners in the industry are constantly catching up with the law as it's developing.
All right, then again, we have a finished movie. Should the filmmaker be concerned about copyrighting the production itself too? The actual movie?
Again, because of the inexpense, it's in the US, I think you said it was $35. In Canada, the actual registration fee is $65. Because of the inexpense and the overwhelming benefit if you have to encounter an infringer, the answer's got to be an unequivocal yes. If we can just go back to some of the comments Jeff made when we were talking about, from a streaming perspective or a downloading perspective, as the owner of the right, can I get to the individual? I can speak to the Canadian experience. This, in 2014, the law has dramatically jumped forward in favor of the owner in the sense of, up until this decision called Voltage in Canada, it was extremely difficult to get any information about an individual downloader or an individual streamer in the sense of the service provider, the ISP, not divulging, and under our privacy laws, not being entitled to divulge information. But our federal court has now ruled that if someone has a bona fide claim and has intention to pursue the right, the individual's email address and their phone number won't be revealed by the ISP, but with a court-approved letter, the individual's address will be forced to be provided from the ISP provider to the right holder, which will enable them as a deterrent to go after those people that, for lack of a better word, illegally download or stream.
We don't have a Voltage case. We don't have a settled law. But there was a case in the DC District Court less than a month ago holding the same thing, and even going beyond that and saying that under certain circumstances you may even be able to get the individual's email address and phone number, which is something you can't get, as I understand it, Scott, at this point in Canada.
Correct.
Now that's a DC District Court decision. It doesn't have precedential value, but the DC District Court is generally one which is pretty respected throughout the country, and that may be the evolving law as it exists in the US.
The most common area of litigation as relates to copyright infringement has to do with music and songs.
Correct.
Can we speak about that?
Sure. So from a song perspective, one of the things that people should know is that we should talk about the exceptions to copyright infringement, because people preview songs online all the time, as an example. And that falls under a category called fair dealing, which entitles the service provider, the provider, and the recipient of the information under fair dealing to sample some of the music. So that falls under a category called research. And the research can also be for consumer research, which makes it legal to sample a short portion of a song. Other examples of fair dealing are if you want to criticize a song, if you want to criticize a movie, if you want to make a satire, things of that nature there's entitlement. But again, from a copyright infringement perspective, if a song is registered and the song is downloaded or illegally streamed, there are rights, and because the cost is so inexpensive, I'm sure Jeff will reiterate this as well, there's no reason not to register copyright and protect the work.
Absolutely.
Do you copyright the soundtrack and all the songs under one copyright, or is it smart to take out certain songs and individually copyright them also?
All right. Well, here the simple answer is substantial taking. So I'll speak to the Canadian experience, and then Jeff can speak to the American one. But from a Canadian experience, if you think that one song is much more prevalent on an album than another, then register that particular song. If the soundtrack has 10 tracks, then 10 times 65 is $650. It pays to register each song as on their own, and you can also do the compilation
Yep.
because it's only $65. But I would highly recommend doing the entire album song by song.
Right, I absolutely agree, because the individual album, song by song, those are original works. The album becomes what's called a derivative work, and there are some issues there which may not exist at the individual level. So you absolutely want to do each song and then try to copyright the entire album as well.
The final question is a question about fair use. And it's thrown around all the time, and I've always felt that the issues relating to fair use are so fact-specific for each case. There's not a general a situation where you can say this does not violate or this is fair under fair use. I'm going to start with Jeff. How do you advise a client as it relates to fair use, as it relates to film? Take a look at Forrest Gump. They took out all these segments from various sources. Did they have to get the consent? Is that fair use?
No, fair use is not consent. Fair use is a situation where you are, as Scott put it earlier, you're doing something which is non-commercial. You're criticizing, you're parodying, you're doing research, you're doing news reporting, you're doing educational things. Those are things, fair dealing, I think it's called in Canada, fair use it's called in the United States. Those are things that you can do which do not infringe on someone's copyright, because you're not using them for commercial purposes, you're using them for other purposes.
But take Forrest Gump as an example. He took from all these different sources and pulled from maybe 15 or 20 different places. How did they do that?
Well, and what you're supposed to do when you're doing something like that is you're supposed to get licenses from various sources, because fair use is, as you put it, very fact intensive, and it's not the easiest thing in the world to assert and win. I've got one right now, which is a case in progress, where we're asserting fair use, and it's a heavy burden.
And again, we've touched on this earlier. If you know or believe that someone's going to extract a small portion of your work because the work includes a phrase which is most popular or something of that nature, then copyright that phrase. The golden rule, and again, it's very fact specific, and we'd have to talk about this off screen, but if 5 words or more, and it's typically copyrightable. 5 words or less, it likely forms into a trademark. But in the circumstances where you have a phrase, Jeff kept on referring to Star Wars references earlier. If you have a phrase that is most popular, then trademark that phrase, and then from a trademark perspective, certainly the right provider would have the right to either grant a license or not grant a license, collect a royalty, not collect a royalty at their command. Meaning, if someone violated the right, they could be sued for infringement.
Exactly. No, that's exactly right.
Okay, so let's end by Scott. If you can tell everyone if they want to contact you,
Sure.
How they would contact you.
Again, it's Scott Miller from MBM Intellectual Property Law. I can be reached by email or telephone. My email address is smiller, MILLER, @mbm.com. My telephone number is 613-801-1099.
Jeff?
And my name is Jeff Schiller. My email, which is confusingly similar to Scott's, is Schiller at D as in David, L as in Larry, E as in Edward, C as in Chicago.com. And my work number is 312-853-8417. Cell number is 847-323-8311.
Okay, gentlemen.
We have a question.
Yes.
Mike Fellow, who should contact a lawyer for illegal downloading, the distributor or the producer?
Of what?
Who should contact a lawyer for illegal downloading, the distributor or the producer of the movie?
For illegal downloading?
It could be either,
Either one.
frankly, in the sense of who has the rights to the film. So if the producer has the rights or has licensed the rights to the distributor, if the distributor has the rights, there typically would be a contract where someone is taking on the obligation to enforce the rights associated with the intellectual property. So in the case where it's the producer would likely reach out to the lawyer. In the case where the contract called for the distributor taking on those obligations, it would be the distributor.
Okay, are there any other questions? Okay, Scott, thank you very much.
Thank you.
Jeff, thank you very much.
Corky, a pleasure.
And we look forward to hearing as new developments happen from time to time.
Thank you.
Excellent. Thank you.
Okay. Our next.
Okay. Thanks, man.